The senator from Oregon.
Mr. President, I will shortly ask...
The Senate is in a quorum call.
Ask unanimous consent to vacate the quorum call.
Without objection.
Mr. President, I will shortly ask unanimous consent that the Senate pass S. 2952, the Stopping Mass Hacking Act. The bill is just one sentence long, colleagues. What it does is simple, but in my view, it is extraordinarily important. If the Senate does nothing, if the Senate fails to act, what's ahead for Americans is a massive expansion of government hacking and surveillance powers, and it will take place automatically on December 1st of this year. The legislation that I seek to pass, that has been bipartisan here in the Senate, would stop this expansion, this automatic expansion of government hacking and surveillance powers. Now, I've said it before, and I want to say it again this afternoon. There is no question that it is a dangerous world out there, and I take a backseat to none when it comes to making sure that our law enforcement and intelligence officers have the tools that they need to keep America safe. In fact, Mr. President, I was actually able to add the specific provision expanding emergency powers for our government to act when there's a threat, emergency powers, so that the government could move to protect the American people and come back and get the warrant later. But that's not what we're talking about here. What we're talking about here is a staggering expansion of government hacking and surveillance authority. These are major changes to federal policy, Mr. President, that are going to come about through amendments to Rule 41 of the Federal Rules of Criminal Procedure. So this is the kind of major issue that traditionally comes before the Judiciary Committee. I say two of my colleagues that I enjoy very much working with. Chairman Grassley is here, Senator Cornyn, member of the Judiciary Committee, distinguished member of the Finance Committee. We have big policy issues that come before the Finance Committee, come before the Judiciary Committee. We work on them. We work on them in a bipartisan fashion. Chairman Hatch and I meet every Wednesday afternoon to work on these kinds of matters. That's not what's going to go on here with this massive expansion of government hacking and surveillance authority. These rules are going into effect, colleagues, on December 1st if the Congress does nothing. If the Congress just says, oh, gee, we've got other things to do, these rules go into effect. And I guarantee you there are going to be many Americans that are going to be very unhappy, and they're going to ask their members of Congress what they did to stop this ill-advised approach. By the way, in the other body, some of the most senior Republicans, Congressman Sensenbrenner, the distinguished congressman from Wisconsin, is very concerned about this issue. So the American people want security and liberty. But these amendments don't give them much of either. This major policy change is going to make it easier for the government to hack in to the personal devices of Americans and collect more information about them. They're going to do it by using computer programs called malware. The mal, in my view, is like malevolent. It's going to make us less safe, not more. By allowing the government to use secret, untested malware, it could end up damaging not only our personal devices, but the power grid or hospitals and nearly any other system connected to the internet. Get your arms around that. Hospitals in Iowa and Texas and Oregon being damaged, not because the Congress made a policy decision, but because something was done automatically as a result of a change in the rules of criminal procedure. I just want to say to colleagues, I think there's going to be a lot of unhappy Americans if that's the case. The rule change says that the government can search potentially millions of computers with one single warrant issued by one single judge. There's no difference in terms of law enforcement access between the victims of a hack and the perpetrator himself. The changes will make people the victims twice over, once by a hacker and once again by their government. You wouldn't punish the victims of a tax scam or a Ponzi scheme with a painful audit. It just doesn't add up. Now, I understand that passing legislation by unanimous consent is a difficult task. These days, you can hardly get unanimous consent to drink a soda at lunchtime. But this isn't an issue where the Senate can do some kind of ostrich act and ignore the problem. By sitting here and doing nothing, the Senate will be giving consent to a substantial expansion of government hacking and surveillance authority. By not hacking, the Senate would give a stamp of approval on a major policy change that has received no hearing, no oversight, no discussion, in spite of the fact that some of the most important companies in America, are speaking out in opposition to this. In my view, the limits of search and seizure are unquestionably an issue for this Congress to debate. The Justice Department should not have the power to change the practical meaning of the Fourth Amendment without the people's elected leaders weighing in. Instead, the Senate ought to be doubly concerned by the fact that the administration wants to conduct proactive cybersecurity policy through some kind of obscure bureaucratic process like Rule 41. There aren't folks in Oregon or Texas or Iowa or anywhere else who are following the details of something called Rule 41. But I'm telling everybody, they're going to be real concerned about the expansion of government's hacking authority. So I hope my colleagues here will join me supporting this bipartisan, bicameral legislation. If this bill cannot pass today by unanimous consent, I look forward with my colleagues to having a hearing on this issue. I know there's been bipartisan interest in the Judiciary Committee on this. Leaders of the Judiciary Committee have talked about it. And I hope that that hearing will take place shortly so that Americans can have a chance to understand exactly how devastating this proposal would be for them. So with that, Mr. President, I ask unanimous consent that the Judiciary Committee be discharged from further consideration of S. 2952 and the Senate proceed to its immediate consideration, that the bill be read a third time and passed, and the motions to reconsider be considered made and laid upon the table with no intervening action or debate.
Is there objection?
Mr. President.
The majority whip.
Mr. President, reserving the right to object, let me start by saying to my friend from Oregon, I admire his passion and I admire his creativity at branding legislation. But for reasons I will explain, this is a common sense procedure that doesn't relate to the Fourth Amendment, the constitutional right to be protected from unreasonable searches and seizures. This is a venue provision. This has to do with what court you go to in order to get a court order, to get permission of a court after establishing probable cause to conduct that search. Senator Wyden is seeking consent to block proposed changes in the federal rules of criminal procedure that have already been the product of thoughtful and lengthy consideration, including public hearing and deliberation. These rules, as all rules that are applied in the courts have been approved by the Rules Advisory Committee. This is a group of judges, law professors, and practicing attorneys. And then it was approved by the Judicial Conference of the United States. And then, most significantly perhaps, they were endorsed by the United States Supreme Court. So if there were constitutional or other legal issues and concerns about this, you would think that the highest court in the land would have flagged those and declined to endorse them, but they didn't. These changes have been approved because they are common sense measures, as I said a moment ago, that relate solely to the appropriate venue for a search warrant. They simply make clear that which federal district court the government should go to in order to apply to a judge for a search warrant in cases involving sophisticated cyber criminals and people like child pornographers and even terrorists. Ultimately, that makes our government more efficient by making it clear which courts can consider these requests for search warrants and better equipped to stop these heinous crimes. As I said earlier, these aren't substantive changes. This doesn't change the balance between privacy and security in the Fourth Amendment to the Constitution. Rather, the government must still go before a judge and make the requisite showing in order to get a search warrant. I can't understand who, but the most radical of privacy advocates would say that even after meeting the requirements of the Fourth Amendment before a judge, establishing probable cause to get a search warrant, you would say, no, we don't want to allow that to happen. I can't imagine circumstances where we would say the Fourth Amendment is trumped by concerns about privacy, especially when the targets that must be proven up in court are cyber criminals, child pornographers, and even terrorists. Well, we can't let that happen, and that's why these rule changes are so important. Our colleague claims the rule changes will allow for mass hacking and forum shopping. That's the creative branding that I told him I admired at the beginning. But these are the same claims that have been considered and rejected through a thoughtful, thorough process that I've already described. These changes are modernizing our laws and updating the tools that government has to investigate so that they can better protect us from the very real and increasing threat of cyber criminals and terrorists. The truth is, there are more things we need to do in addition to this to update and modernize our laws. I would just close, Mr. President, by saying I know that there's been public concerns raised, and indeed I believe there have been some briefings, even today, by federal law enforcement agencies and the intelligence community with regard to Russians' activities in cyberspace, even focused on our very system of electing our officials in the November 8 election. This is not a time to retreat and to allow cyberspace to be run amok by cyber criminals or people who would steal intellectual property or child pornographers or terrorists. This is a very sensible tool, a venue. It just says where the search warrant can be sought, not the substantive requirements for what needs to be proven. That is preserved under the Fourth Amendment to the Constitution that protects all of us, as it should, against unreasonable searches and seizures. So for all those reasons, Mr. President, I will object to the unanimous consent request.
Objection is heard.
Mr. President,
The senator from Oregon.
I'm going to yield in just a moment to Mr. Daines, but just so we're clear in terms of my response to the distinguished senator from Texas, he has, as some have tried to do, sought to characterize this as kind of a routine kind of matter, that this was a rule of criminal procedure of no great import without any far-reaching consideration. I can tell you, Mr. President, cybersecurity experts around the country have spoken out virtually unanimously about the consequences of the government accidentally breaking their computers without telling them. I don't know of anything that is routine about this at all. Under this change, the government can search potentially millions of computers with one single warrant issued by one single judge. And tragically, there's no difference in terms of law enforcement access between the victims of a hack and the perpetrator themselves. So we're talking about clobbering victims twice. First, they get clobbered by a hacker, and then they could get hurt by the government. Now, the distinguished senator from Texas seeks to portray this as some kind of far-out kind of matter. Virtually all of the major technology companies in this country have written in opposition to this. Scores of cybersecurity experts have written in opposition. And one of the key points they make is you don't punish victims twice in America. You wouldn't punish the victims of a tax scam or a Ponzi scheme with a painful audit. That's what can happen here. And the idea that a change of this magnitude would be made without any debate, consideration. There's been no hearing on this matter, Mr. President. I know of no meetings. I'd like to hear any member of the United States Senate tell me about some meeting they went to. I know of no sessions where the public voice could be heard. So I'm very hopeful, and I intend to come back to this floor again in an effort to try to make sure that the public is at least brought into this. Because I can tell you, Senator Daines and I represent a lot of rural hospitals, for example. Well, certainly if you have some of what we've been told could happen in terms of what it could mean to computer systems at hospitals and other kinds of facilities, they're going to ask their senators, what'd you do about that? Why'd you just let that rule go through that would damage those systems that are a lifeline for Americans? So we're going to be back, and as I mentioned before my colleague came, in the other body, we're starting to make a fair amount of progress. Jim Sensenbrenner, a very influential member of the other body, has taken a great interest in this, a number of colleagues on both sides. So we'll be back. I'm going to yield now, Mr. President. I know my colleague from Montana, who's been a wonderful partner in this effort, has some comments to make. It highlights once again the bipartisan concern about how the magnitude of this change, colleagues, would take place without any involvement, none, here in the United States Senate. No hearings, no debates, no discussion. This is a big change, and I hope we'll discuss it. I yield the floor.